On the record, Dakota Nisley.
Case number 19-0195, State of Ohio versus Dakota Nisley. Hearing set at 2 o'clock, it's now 2:08. Nisley was originally put under control back on January 8, 2020. Period of compliance with your felony. Notification filed violation of Article 629, alleging violated conditions of his control. The defendant was notified on mail, although we still got wrong address on it, that involved the request from the base or involved in contact this time.
Yes, sir. I spoke to him last week. Been on week reporting for most of this year. He's been compliant with that, so I'm surprised out here.
All right. Well, going to order the case position for his arrest, and if you should have to get a hold of him today, in the morning, we'll deal with it, but we'll hold off for it.
All right, okay.
Thank you.
Balls are higher, sir. Good. Mr. King.
Okay.
Sworn, just doesn't know when you up.
That's right, Your Honor.
Okay.
On the record, Collins, Your Honor.
Case number 22 CR 92, State of Ohio versus Donald Ray Collins. Present for the state is the Assistant Prosecuting Attorney advocate. Present for the defendant is Attorney David Wagner, and you are Donald Ray Collins.
Yes, sir.
Mr. Collins is charged with and he's charged with counts 1 and 2. The 1, 2, 10, and count 1 and 2 is charged with aggravated trafficking, first degree felony, aggravated possession, second degree felony, and count 10, aggravated trafficking, sensual, same thing, adhere. And that was originally set for trial day. Some time ago, Mr. Wagner asked that to be vacated. Actually, I just think I did last off, but I just noticed that I had signed entry over. I had done that, so I just signed it today. And set with the plea hearing that was previously published by the sign commissioner. So I have been presented with a plea of guilty form here, Mr. Collins, which is a three-page document, prosecutor's office prepares, and it indicates you're going to plead guilty to the defendant charge of count 10. On page 3, there are signature lines, and about quite halfway down the page, there's a sentence that says I entered this plea voluntarily. Immediately below that, there's a line for signature defendant, and I see there Donald Collins, and that's your signature I'm looking at.
Yes, sir.
And did you just sign this document here this afternoon?
Yes, sir.
Now, when you sign this document, did you understand that it's a agreement to plead guilty, which means there will be a trial and actually application to sentencing?
Yes.
And you went over with your attorney before you signed it?
Yes, sir.
And is this something you and he had been discussing before today?
Yes, sir.
When you came here today, is this something you thought about on the app?
Yes, sir.
Alright. Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
And you feel that you had enough time to fully consider this matter before making this decision?
Yes.
You're not in pressure rushing anyway to do this?
No, sir.
Alright, the agreement states on page 1 that you're going to plead guilty to defendant count 10, aggravated trafficking, methamphetamine, and third-degree felony. And I assume that's going to be based upon the condition of the allegation that occurred in the illegal school zone.
Yes, sir, Your Honor.
Alright. And so what that does, a second-degree felony that you're charged with in that count will carry a mandatory prison term set by the judge of 22 to 8 years. It could be extended by up to 50% of where the term of court goes if you were if the Department of Corrections felt that that should be done. Now, by amending the indictment to reduce it by 1 degree, that changes the possible penalty from the mandatory 2 to 8 years minimum to a possible term between 9 and 36 months in increments provided by law, which 9, 12, then 18, and then every 6 months up to 36. There's also a fine available of $10,000, mandatory fine $5,000, and possible license suspension of 6 months fine. You understand that?
Yes, sir.
Now, in this case, third-degree felonies, there's a presumption that the prison term should be imposed, but it's not mandatory. So the court can just choose granting control instead of sending to prison. Now, other than this case, are you facing any felony charges in any of your possession? And are you currently on community control, probation, parole, or motion control for a felony?
Home reporting probation.
Other than this case?
No.
Okay. So not any other courts?
No, sir.
Now, under the law, if you should be convicted, Mr. Collins, and if you should be sentenced to prison, then once you complete the prison term imposed by the court, it is possible that the adult parole authority may choose at their option to push under post-release parole supervision for up to 2 years. So they make that decision on the judge doesn't have anything to do. If they decide it should go, it will supervise the terms they set by parole officer. And if during that period of time, they determine that you have failed to comply, then they can return you to prison, maybe serve an additional period, even though you serve the entire term set by the court, for an additional period up to 9 months for any single violation. But there's a cap limit of half of whatever the prison term was imposed by the judge for all violations. But if you commit a new felony on post-release control supervision, then an additional whatever sentence the judge in the new case imposed upon you, the judge could also sentence you to an additional period of 1 year or whatever time is left on that post-release control, whichever is greater, committing that new felony on post-release control in this case. And that will have you serve consecutively to that sentence in the new case. You understand that?
Yes, sir.
Now, under the law, as I indicated earlier, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison control sentence, which means instead of being sent to prison, you can be put under the supervision of probation officer, the term set by the court for a period of up to 5 years. Now, if during that period of time the probation department felt that you were not complying, they might file a written notice at the court, give you a copy of the hearing. You have an attorney at that hearing. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your control, then sentence you to 6 months and fine you $10,000. You understand that?
Yes, sir.
Now, the charge in count 10, as amended, and what I'm going to do here is delete the city school zone. Put my initials in the date. And so, as I believe the allegation of the sentence, and so as that is deleted, this charge now reads: on or about April 13, 2021, Huntington County, Ohio, you did knowingly sell or offer to sell methamphetamine and Schedule 2 controlled substance not equal to the city bulk amount less than 5 times bulk amount. In violation of section 29.5 So that's now as it reads there, a third-degree felony with the penalties that I just described. Now, Mr. Collins, you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the evidence of the case, possible legal issues of the case, possible defense of my trial, raising trial, possible outcomes of the trial of your attorney?
Yes, sir.
Are you satisfied with this advice and confidence in this matter?
Yes, sir.
Are you under the influence of any type of drugs or alcohol at this time?
No, sir.
Have any threats been made that you plead guilty here today?
No, sir.
Now, on page 2, there are several lines that are printed in bold and underlined, and I'll read those as follows. Finish on plead guilty to count 10 as amended. State dismiss remaining counts. State finish on recommended control. And agrees to repay $599 task force as follows: $140 and $300 loan, $320 from several property legal line and Tangy Fisher, and agrees to cooperate fully in prosecution of all offenses. That's your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that issue to be guilty here today?
No, sir.
Now, under the law, the matter sentence of the judge, not the parties. So, even though there's a agreement that you are going to be recommended by the state to get probation control, of course, not required to follow that recommendation. So, once I've heard all the information submitted at the sentencing hearing, I decide that's not the appropriate sentence. It ended up getting a prison term of 36 months. Understand that?
Yes, sir.
Now, do you hold any kind of license or certification from any state agency or that regulates any profession or occupation?
No, sir.
Now, you have certain constitutional rights, understand, where it can separately. First, you have the right to have counsel, and Mr. Wagner appointed representation, and that wasn't simply to work a case out, but provide any defense that could be available to you in the law that you would like you to provide. So, if you decide you want to do this, if you want to defend this charge, he'll continue to represent you, and including a trial, if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Collins had a right to have a jury trial in this matter, in which 12 people would be selected citizens of Lincoln County for the summons for jury duty on their trial day. After they are selected, the evidence will be presented, it will start on the law, on the judge, and then that jury will decide by unanimous verdict on 12 after 3 whether the state proved your guilt or proved guilty of that. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means to give up in the legal sense in writing, the right to have a jury trial. And in that case, then, you would have a court or bench trial, which means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt or proved that. You understand that?
Yes, sir.
Mr. Collins, under the Constitution, excuse me, you have a right to file witness against you and cross-examine through your attorney of the court. that means the witness may have come in for testimony, in open court, in front of you, and your attorney, and anyone else may be present. After the prosecutor then asks a question, your attorney asks a question, that's called cross-examination. For that's part of your evidence to help for side of the case. Understand that?
Yes.
Now, under the Constitution, you have a right to use power of the court to compel or force witnesses to come into court to testify for you, side of the state. So, if you have witnesses you're not certain going to come in voluntarily, it's your request for police report or for some called subpoena, and of course, those witnesses come to court and be able to testify if one of them to, even though they don't want to be here. It's the same way the state's witnesses will require to come to court. You understand that?
Yes.
Now, under the Constitution, you have a privilege against self-incrimination. All for each time before she evidence this matter at any time, including the trial. No one can ever make a testify. Prosecutor can't, judge can't make that decision. Decide not to testify. The fact that you did not testify, not used against you in any way by any person at any time. And no one's even allowed to comment about it, except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that you lost. That is your right. They can consider it for any purpose. You understand that?
Yes.
And under the Constitution, you're presumed innocent until proved guilty by the state of Ohio on every essential element of the defense charge. What that means is that the burden of proof is on you to try to prove that you're not guilty simply because you've been accused. The burden upon the state to prove that you're guilty. So at trial, you are not even required to offer any evidence in your defense. And may, it's not required. Whether you offer any evidence or not, the burden of proof will remain upon the state of Ohio. Prove your guilt on every essential element of the offense charge and prove beyond reasonable doubt, which is the highest burden of proof known under the law. You understand that?
Yes.
All right, now, originally entered plea not guilty, Mr. Mullins had plea denied allegations that the indictment denies committed a crime. That plea exercised or revoked all the rights that I just described. Now, if you change your plea from not guilty to guilty, that's the opposite of not guilty. Guilty plea, and that's the allegation that the indictment that's a crime, that you committed that crime. And that plea waives gives up all the rights that I have described for you, except right hand of attorney. Or that right hand of attorney, no matter what you're doing. So with that exception, you're pleading guilty. Waive give up the right to jury court trial, waive give up the right to prompt witness against you, prosecute your attorney, waive give up the right to private court, tell a court witness in court to testify for you, just like the state. Waive give up for proving your self-incrimination because you want to say you're guilty, that's what you find is guilty. You would waive give up for innocence because the state is guilty, the state's not required to prove you. It subjects you to the sentence to be by the court. And finally, it waives up any right to file appeal, which you may have had up to this point in the case. And if I should sentence you to the maximum sentence, or other circumstances you file appeal, that may have to be filed within 30 days for sentencing to be filed. You understand all that?
Yes.
And are you a U.S. citizen?
Yes.
And you've entered into this plea agreement voluntarily?
Yes.
Now, do you have any questions about the charge as amended or possible amendment?
No, sir.
You understand?
Yes, sir.
Any questions about plea agreement?
No, sir.
You understand that?
Yes, sir.
You understand the recommendation as the sentencing not binding on the court?
Yes, sir.
Have any questions about the constitutional rights of this claim?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea guilty, what it means, what will happen if you hear that plea here today?
No, sir.
You understand that?
Yes, sir.
Is there anything you need to speak to Mr. Wagner about before we go any further?
No, sir.
You have any questions about anything I have explained to you here today?
No, sir.
It is your decision to withdraw your outgoing plea guilty to count 10 as amended. Pursuant to terms of this written plea agreement.
Yes, sir.
All right, then as to the charge as amended in count 10, that reads that on or about April 13, 2021, Huntington County, Ohio, you didn't know the seller offered settlement penalty and scheduled to control substance penalty for receiving bulk amount less than 5 times bulk amount in violation of section 29.25.381 Franchise Code. A charge of aggravated traffic penalty for your funding during month prison term 9 to 36 months in the increment provided by law. A fine of $10,000, mandatory fine of $5,000, and a authorized suspension for 6 months, 5 years. Court final is state of the court defense by all constitutional rights being no result of voluntary waiver, same sentence from 11, please accept the trial. Then found guilty of count 10 as amended. The remaining counts against the defendant are dismissed. Court orders that Matthew refer to the probation department for his recent investigation. The report shall include assessment for substance abuse and or mental health issues, and possible treatment, sentencing will be on August 17th, and again, on the evening. So we need to get a side notice from your bailiff, and then we need to have information on the half point this week, and make an appointment to see the PSI officer. Very report. Any further counsel?
Mayor, yes, sir.
All right, thank you.
All right, Mr. Collins, sign this.
Did this firm try, you want to see something?
No, straight down, see Mr. Fulton.